Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 44, Common Cause, a registered society versus Union of India and another 2018 Supreme Court judgment which deals with passive euthanasia. Apart from that, one more information I would like to articulate here is that Supreme Court has released some preparatory lectures. These lectures will take place online and they will be in the live form on the WebEx. Okay, so on to today 5 p.m. onwards, there will be a lecture on drafting, and there will be a lecture on 21st and 22nd May with respect to advocacy and professional ethics, and the paper on leading cases. Okay, so you can download WebEx on your desktops, mobiles, and you can have the access to how the lectures are being done. So these lectures are most likely to be done by the legal luminaries like the senior advocates, people who are very enriched with the legal acumen. They will be conducting these lectures, right? So you can also access the material. And here on the channel of Legal Darshan, we are continuing with the information, with the cases that might help you in your exam that are scheduled in the middle of the June. Now, coming back to the judgment, we are discussing today the judgment of Common Cause versus Union of India and others. Now, before we start this judgment, there is a whole judicial journey that euthanasia has carried out. So the journey starts from the case of P. Rathinam, goes to the case of Gyan Kaur, then comes the case of Aruna Schonbach, and then in 2018 we have the case of Common Cause. So it's a four layered litigation that is happening with respect to euthanasia, with respect to right to life in the country of India. Okay, so what happened in P. Ratinam and Gyan Kaur, they are basically related to IPC provision 309. Okay, so section 309 is the provision for punishment of suicide. Okay, now 309 talks about suicide. One who attempts suicide shall be punishable. Now, in P. Ratinam, the legality of Section 309 was adjudicated, and it was held that this section is unconstitutional because a person do have a right to live and also has a right to die. So it is on the person whether he wants to take his life or whether he does not want to take his life, and therefore section 309 is not so much relevant when it comes to penalizing the suicide, because in P. Rathinam, we actually, the judges are looking at that, when somebody wants to attempt suicide, somebody wants to, die, it is not because it is coming out of sheer interest or something, but rather it is an intention to give an end to their prolonged misery. So this should be treated with some sensitivity and therefore should not be penalized. So in P. Rathinam, we are talking of 309 to be not a very good provision, and therefore it is against the idea of right to life. Whereas in Gyan Kaur, the right to life, it was upheld because state has a guarantee to protect your lives, and section 309 goes alongside the narrative of section 300 goes alongside the narrative of state's guarantee of protection of life. Therefore we come to the judgment of Aruna Schonborg. In Aruna Schonborg, the case was a very critical case. A nurse was raped right there in the hospital. She was in the vegetative state for so long until one of her acquaintances applied for her euthanasia. So the court granted euthanasia considering the vegetative state, and there was no recovery in her health. It was just a prolonged treatment for prolonging her life. So court did grant her passive euthanasia, but the court referred the matter to a larger bench in this case, and the larger bench therefore is addressing the legality of passive euthanasia in the case of Common Cause versus Union of India 2018 judgment. Now, what is happening in this case is the court is looking at the details. First, the court is basically looking at how P. Rathinam, how Aruna Schonberg, how Gyankor has looked at the judgment, and then court is basically the moot question before the court herein is that does the right to live with dignity also entails the right to die with dignity? Another question that court is examining is what is the constitutionality and legality of passive euthanasia in India? Can a person execute a living will Okay, can a person say that I want to die by a living will, or advance directive? Can he issue advance medical directive in anticipation of terminal illness or incapacitation? And fourth is that how will you, if you allow passive euthanasia, what would be the procedural setup that would help you to, prevent the misuse of the application? Now, misuse of the application of the provision of legalizing passive euthanasia. Okay, now what here is euthanasia? Euthanasia is basically when you want to end your life. Okay, now there are two kinds. Is this the court herein is looking at two kinds of euthanasia, one being the active, another being the passive. So in active euthanasia, it is just your will. It is just your will that you want to succumb to your life, and the doctors cooperate with that. So active euthanasia is not allowed in the Indian context, whereas passive we do allow by virtue of the judgment given in the case of Common Cause versus Union of India. However, there is still no legislative effort made to incorporate passive euthanasia as a legal measure. This judgment operates as the law under Article 141 of the Constitution of India, right? So now what is happening? Passive euthanasia is being allowed. The court is saying that wherever artificial prolonging of life is being done by the medical procedures, by the medical methods, there is an option given to the person who is under treatment to give a consent to, end his life. And in case of terminal illness, in cases, the court herein is saying that in the case of terminal illness, continuation of life prolonging treatment may violate an individual's autonomy and dignity, right? So basically, in this case, the petitioners have argued that Article 21 includes the right to live with dignity, and therefore when there is a right to live with dignity, that also automatically extend to right to die with dignity also. And there is a principle of informed consent and bodily autonomy that needs to be considered. So there are, the petitioners are raising that living wills are globally recognized and they also should be given some validity, some constitutional protections in India. Whereas the state herein is arguing that parliament should legislate on this matter and state has an obligation to protect life, because it is all boiling down to state's protection to life, state's guarantee to protection of life. And the state is here worried about that euthanasia may lead to misuse, especially when there is no adequate regulatory measures, because parliament is yet to legislate on this issue. Now the court herein is observed that Article 21 does not only entails the right to life with dignity, but it also assures an individual the right to die with dignity, wherein life means a life of dignity, autonomy, and choice. And the choice includes the choice to refuse the medical intervention in certain cases as well. So if one person knows that he is terminally ill and that the survival chances are very meager, he can execute a living will of denying the treatment, of prolonging his life by coming on the life support, and therefore succumb to his death naturally, right? Life. So the court herein is looking also, we started this judgment with one thing, that court herein is also reiterating the difference between active euthanasia and passive euthanasia. So the court is basically talking of that active euthanasia is a lethal injection or a lethal injection of death, a lethal act of death, and which may fall in the purview of causing, culpable homicide or causing murder. So it is, I am now, this is an interface I just explored on the Supreme Court's website. Yes, the court is looking at the euthanasia, that there is a difference. In head notes, it is mentioned that there is a difference between active euthanasia and passive euthanasia. When you talk of active euthanasia, it means that there is a direct act to cause death. There is a lethal injection of death. But when I am talking of passive euthanasia is basically I am withdrawing my medical treatment or my life support when continued existence is medically futile, because I know that I can just prolong my life, but my ultimate result will be death because of the disease I am, diagnosed with. Now, the third aspect the court herein is looking at is the aspect of is the aspect of living will and advanced medical directives. Okay, so what exactly is a living will? The court herein has, yes, what is the living will? The court herein is looking at it. Yes, so the court in this case is looking at what exactly is the, I, I'm pardon me, my screen is a little non-functioning at the moment. Okay, yeah. So basically, court herein is looking at the living wills. Court herein is saying that an individual has the right to decide in advance not to be subjected to life prolonging treatments when faced with terminal illness or permanent vegetative state. So court herein is saying basically that if I know that the disease I am suffering with, if there is a disease that I am suffering with, has no treatment. Ultimately, I will be in the vegetative state. Ultimately, I might go in a state when I will not be aware of what will happen to my life. And the treatment is so crucial that it is just to prolong the life so that, and ultimately I will be, then in that case, I can execute. Yes. Okay. We have it here. I advanced directives. Yes. So I can execute a living will. And this particular principle is flowing from the individual autonomy, bodily integrity, and the principle of informed consent. Because it is my body, it is my treatment, it is my integrity, that why would I want to undergo and suffer, pain, suffer grief, suffer all the medical equipments around me when I know that I am terminally ill, and my state, my diagnosis will be, leading me in a permanently vegetative state. So bodily integrity is in question. The principle of informed consent is here, that if I consent to my own termination of life, it is protected under Article 21, because court herein is prima facie saying, court herein is primarily saying that Article 21 does protect your right to life with dignity and your right to die with dignity as well. Right to die becomes a part in your Article 21 scope. Okay. Now, but when I'm allowing passive euthanasia, court herein is saying that active euthanasia will not allow. But when I am allowing passive euthanasia, but there is no legislative action on passive euthanasia, there is no legislative effort. So till then, the court is laying down the comprehensive guidelines over it. So now in this case, the court is basically laying down some procedural requirements that we need to execute if passive euthanasia has to be undertaken. Yes, so we will just come to, yes, these are the directives that the court needs, that they should be satisfied when one has to undergo passive euthanasia. Okay. So this judgment is available on the DGSTR website and you can access it from there. I am using the head notes of the judgment, which will also be given to you in your exam, right? So now in this case, the court is laying down the directives. So court is saying that the living will, the will which is made out of informed consent, that I want to terminally uh, end my life, it should be made by an adult who is of sound mind and free will. So it should not be made in coercion, it should not be made by fraud, it should not be made by someone who is unsound of mind and who is not able to understand the consequences of what he is doing. Okay, he must, in the living will, it must be stated that circumstances under which medical treatment can be withdrawn. So if I say that initially some efforts could be made, but if the efforts are failing after 3 or 4 months of me being subject to medical treatment, the support may be withdrawn if there is no recovery. Okay, such could be the cases that I can mention in my living will. Okay, then the decision is informed and voluntary. My decision should be well informed. Okay, so how is this information coming? Is by the medical experts, or whatever my report is, the doctors do have a right to tell me what I am suffering from, and I have the right to know. So if I know that I am suffering from a terminally ill disease, then in that case my life support or my medical treatment could be withdrawn. That makes my decision informed and voluntary, right? Then it must be signed by the executor. So I should be signing it in the presence of two independent witnesses, and it should also be attested by a judicial magistrate first class, who will preserve the copy and will also send it for the execution to the district jurisdictional court. Okay, Now, um, what happens if what happens after the living will? How is it implemented? Now, if the executor, okay, so if I executed my living will and I'm not well, I am terminally ill or I am incapacitated, then the hospital constitutes a primary medical board. It generally consists of three doctors with at least 20 years of experience. The decision is sent to the district court, which shall constitute the second medical board. And when there is a second medical board coming in action, the decision, the whatever the decision of the two medical board is, it must be, when it is concurred by the two boards, it must be informed to judicial magistrate first class, and who will visit the patient, who will verify the genuineness of the advanced medical directive of the living will. And if he is satisfied, if the person is satisfied, then the directive, if the JMFC is satisfied, then the directive will be implemented. Okay. Now, even without an advanced directive, even without a living medical will, a living will, even without a living will, family members can also approach the high court. Because if I am I don't know, I am a very happy person, I don't want to die, and if I get terminally ill, I get diagnosed with some disease and I become terminally ill, and in this case I am incapacitated to give my consent because I am most of the time on the medication, then what happens in the case when I do not have a living will? So in this case, the judgment is also allowing family members or the doctors as well to go and approach the high court seeking the permission for passive euthanasia following the same procedure. Now, who family members could be are the direct kins, the wife, the children, the parents. They are the direct kins who will be the family members, or even the treating doctors. They may approach the high court and they can get the euthanasia done. But we should be very mindful that the conditions are so that they demand euthanasia. Either the person is terminally ill or in the vegetative state. It cannot be invoked for merely suicidal thoughts. It cannot be invoked for just small diseases, the diseases which are not very chronic in nature. Okay, just because there is a misery, this provision cannot be invoked. All right. So this was it for the video on Common Cause versus Union of India. The judgment is emphasizing constitutional morality, and it is also meeting the medico ethics along with the dignity and freedom of choice of the individual. Advanced directives are the product of, the principles of informed consent and autonomy. So the court, especially Justice Sikri in this case, is stressing that consent is the key facet of medical treatment. So even if I am subjecting myself to withdraw the support, the life support I am on, it should be informed and voluntary consent. And passive euthanasia is not a tool that is, extinguishing life, but it is extinguishing the treatment, which is futile and only prolonging misery and only prolonging the suffering of a person. All right. So this was one judgment wherein we studied about active euthanasia, passive euthanasia. We had a corroboration with the previous judgment, P. Ratinam, Gyan Kaur. We had the Aruna Schonberg, a very terrible case happening to her. And then we are governing medical consent and the consent by autonomy, informed consent, and acting living wills, advanced directive in this case. So I hope this discussion was useful. The court's guideline here in this case have the force of law under Article 21 remaining binding until a statutory provision is enacted, and therefore marking this judgment as a milestone in Indian constitutional jurisprudence, especially with respect to Article 21, which provides for right to life with dignity. Thank you, everyone. Have a nice day. Please stay tuned with Legal Darshan. Keep watching, keep subscribing. Have a great day.